uh, recording. I'm very pleased to introduce our speaker today, Will Aitchison. His topic is going to be just the facts, vaccine mandate litigation. He's talked a little bit about what he's going to cover, and it's just going to be a very broad and comprehensive review of this, and I'm really looking forward to it. We're going to have a question and answer period at the end, but also during this, Will has said that he would address some questions that might be appropriate to different sections, because his presentation will be broken into some topics. So if you have questions, please put them in chat, and we'll try and get those. And Will may actually ask for some questions at the end of his different sections. So Will is a practicing attorney. His bar memberships in a wide area of California, Alaska, Oregon, and Washington. That must keep you busy traveling a lot, I would guess. He received his Doctor of Jurisprudence from Georgetown University Law Center. His company is a public safety law group in Portland, Oregon, and he primarily represents public sector labor organizations, primarily police officers and firefighters. And he covers collective bargaining, really all aspects of labor relations, litigation of the Fair Labor Standards Act, and federal and state legal cases. I thought this was interesting. He has represented over 100 different labor organizations over the course of his career, and he has participated in more than 500 arbitrations. So he's got a wealth of information for us. He is the founder and director of the Labor Relations Information System, which is a valuable resource for public sector safety labor relations. And he has seminars, a monthly newsletter, a monthly podcast, and assists with communications. He's written, I don't have probably the right number, about 10 books, and 6 of those are still in print. Is that about right, Will?
That's about right.
Okay. And I could go on for a long time about Will's distinguished career, but I think I'm going to turn it over to Will and let him get started. One question, Will, is there anything else that you would like to mention about your career that I didn't cover?
No, that's just fine, Mickey.
Okay, well, it's all yours.
Okay, I am going to share my screen now. First of all, let me get something very important out of the way. I want to give a shout out to my friend Betty Widgeon up there in Michigan. I see she's on this call, and that's just great. Let me start the PowerPoint going. Okay, Mickey, are we all set on the PowerPoint? You can hear me and everything?
Yes.
Great. So my topic for today is...
Are you sharing your screen, Will? I guess you are. And
yes, I am.
Very good.
My topic today is talking about kind of the swirl of litigation that concerns mandatory vaccination requirements. And we've seen just a flood of litigation showing up in a wide variety of different forums. So we see it in courts, we see it before arbitrators, we've seen it before labor boards, mostly state labor boards. And over time, I think the rules have become fairly clear, but that doesn't stop new lawsuits from being filed almost every day about mandatory vaccination programs. The 3 most frequent questions that I see being asked about these sorts of programs is whether an employer can legally have a mandatory vaccination program or a program that I think of as vaccination or testing, where you have to either be vaccinated or be subject to periodic testing, weekly or semi-weekly testing, whatever it might be. The second question is, what exemptions an employer must have from a mandatory vaccination policy. And then lastly, what concerns us most, I think, in this room, whether vaccination policies are negotiable. If so, what is being negotiated about them? And what happens to these policies when you get into arbitration, when you get into either grievance arbitration or interest arbitration? And now we have a number of decisions, a little bit more than a half dozen of arbitrators addressing vaccination in one way or another. I got called into this completely by accident. When the first vaccination cases started being created, or started being issued in June of 2021, I scouted around to see if anybody was tracking the litigation and how it was coming out. And I started with the usual place I start for things like that, which are the large employer side law firm blogs, because they do a very good job of tracking these sorts of things. And to my surprise, nobody was doing it. And so I built a table and I provided it to Mickey along with this PowerPoint. So if anybody wants it, it hasn't been distributed, just get in touch with Mickey. I built a table that I have added to once a week ever since of all reported vaccination decisions that I can find in the country, no matter what kind of forum it is. Eventually, I had to start paring them down because there were too many. The table got to over 100 pages long. And so now it's down to a more manageable 50 pages. And from that table and from those cases, you can see a wide variety of themes. And as I mentioned, they're consistent themes. But I want to start off with exposing you to what you see when, particularly in the public sector, which is where I apply my trade, what you see when you have a mandatory vaccination program that is introduced by an employer. I'm going to show you two very quick videos. The first is of an Oregon state trooper, and the second is of a fire captain in the city of Los Angeles. And trust me when I tell you, I have been to union meetings all the way from Boston to Los Angeles, where I have heard people like this say things just like this.
I'm a Christian, a husband, a father, and a police officer. I swore an oath to uphold the Constitution of the United States, to protect the freedom of the people who pay my salary. I do not work for my governor, but for them. The governor elected to this beautiful state has ordered medical workers, teachers, and first responders to get the vaccine. I have personal and religious reasons as to why I will not take the vaccine, but also the freedom to choose not to. I'll likely get fired over this video, but I'm nonetheless exercising my First Amendment right to speak freely. I've fallen in line for over a year with these useless and effective mask mandates, and I will no more. I will not sit back and sheepishly watch as those who serve the people of this state are given unlawful orders which threaten their livelihoods should they choose not to fall in line. Discretion is one of the most important parts of my job as a police officer. I will use that discretion, and I will not enforce useless mask mandates or unlawful vaccine orders.
My name is Christian Granucci. I'm a captain with the Los Angeles City Fire Department. I'm a 31-year veteran with this agency. Our union representation stood by idly and played a wait and see and sat on their hands. If we do not take the vaccine, we have to be subjected to testing twice a week. If we refuse that, termination. This is tyranny. This is about freedom of choice. And I am putting my administration and my union on blast. There is a large group of us, in the hundreds, and we have an attorney on retainer, and he is a shark.
So how are these cases coming out? Both of those gentlemen did file lawsuits. They were part of class actions, and both of them, they lost. And that is nothing new. As of the time I updated this presentation in preparation for this meeting today, by my count, 78 courts in the country had ruled on the merits of individual challenges. Individual challenges, I mean, not by unions, but challenges filed by employees to mandatory vaccination policies, challenges where the employer had medical and religious exemptions. I'll come back to those two topics in a moment, of course. 76 of those courts had rejected the challenges. Only 2 courts had ruled in favor of the employees. And the first one was a case out of whoops, sorry about the dog thing. A case out of Northwest Florida where the employer failed to put on any evidence supporting a mandatory vaccination policy. And the second was a case out of Louisiana where there was a peculiar state statutory system that, and this was a school vaccination requirement, a college vaccination requirement, where the state statutes allowed exemptions for students who filed written dissents, but the state had not created such a system. So I view those 2 cases as being very sui generis, and that the courts really didn't get to the underlying heart of the merits of a mandatory vaccination program, the legality of it. And really, I think we have effective uniformity in the courts, rejecting constitutional and statutory challenges to mandatory vaccination programs. Note, I am not including the federal cases, the ones where OSHA, there were challenges to OSHA's emergency rule mandating vaccines in larger workplaces. I'm not including those because those involve very different principles. Those involve principles of separation of powers and the authority of the executive to act in areas where the legislative branch has not done so. These are cases with individual employees saying, my employer cannot impose a mandatory vaccination program, and the court's rejecting those challenges. Now, why? What's going on in court? And the most common argument that you see is a 14th Amendment argument. And the 14th Amendment argument is one that we used to call, haven't seen much of it lately, substantive due process, not procedural due process, but substantive due process. That we have the rights to the autonomy in our bodies. It's kind of akin to privacy, right? And that the government may not invade those substantive due process rights of bodily integrity. And why are those cases coming out against employees? And the answer is the Supreme Court decided the issue as you can see from this slide, about 117 years ago, in a case called Jacobson versus Massachusetts. Jacobson was a statewide vaccine mandate. It actually allowed local cities to participate or not participate in the mandate. The disease, of course, was not COVID, it was smallpox. And significantly, there were no exemptions, no religious exemptions or medical exemptions. If you violated this law, if your local jurisdiction had adopted it or not opted out of it, violations were punishable by a $5 fine, and jail resulted if you didn't pay the fine. And that's what happened to the plaintiff here, who was a minister. He opted not to pay the fine and he was jailed. filed a lawsuit under the 14th Amendment claiming substantive due process, and the court ended up holding that the vaccine mandate was in fact constitutional. What was the court's rationale? You can see the quote on the bottom left part of the page, that while we do have liberty rights, the liberty of bodily integrity, for example, in our context right now, while we do have liberty rights under the 14th Amendment to the Constitution, those rights cannot go beyond what is reasonably required for the safety of the public. And in the context of vaccination, the court said, the safety of the public we will defer to the reasonable decisions of public health officials. Jacobson was written by the great dissenter, right? Justice John Marshall Harlan, one of our greatest Supreme Court justices, I think, of all time. And you can see this quote from Justice Harlan, that real liberty for all cannot exist if there is a principle that each of us can do what we want with our own property, our own person, regardless of the injury that may be done to others. In other words, that the interests of the whole in liberty have to prevail over individual interests, particularly in times of a public health crisis. Well, that's Jacobson. That's 117 years ago. What's happened to Jacobson over those 117 years? Well, the Supreme Court has reiterated Jacobson twice, most notably in one of the Jehovah's Witness cases from the 1940s. This is one called Prince versus Massachusetts, and it involved a mandatory vaccination program in the schools. And by the way, the legal principles for mandatory vaccination programs in schools are, as nearly as I can tell, identical to the legal principles of vaccination programs in employment. So, but this was a school case, and you can see that the Supreme Court held that, look, a parent can't claim freedom from compulsory vaccination programs on religious grounds for their child any more than they could for themselves. And they couldn't under Jacobson. And so the court in Prince upheld the mandatory vaccination program. The most important case right now after Jacobson is this case called Clausen versus Trustees of Indiana University. This is a school case, and it involves Indiana University imposing a vaccine mandate for all of its students as a condition of attending the university. There were religious and medical exemptions. This case went to a federal trial court, and the trial court wrote, I think, a really beautiful, about 108-page opinion. And when I say beautiful, I mean, there's just, without regard to result, the opinion was just really well done from a constitutional standpoint. And the trial court judge upheld the vaccine mandate. Then it went to the Seventh Circuit and ended up in the hands and under the pen of Judge Frank Easterbrook. And those of you familiar with Judge Easterbrook know that he's never going to write anything that is 108 pages long. And in fact, he wrote something that was about 7 pages long and upheld the trial court's decision. Why? Judge Easterbrook said, look, this is an easier case than Jacobson for a couple of reasons. First of all, Jacobson didn't have exceptions, and Indiana University has medical and religious exemptions. And secondly, Indiana doesn't say that every adult member of the public has to be vaccinated the way Massachusetts did back in Jacobson. Instead, vaccination is a condition of attending Indiana University. And people who don't want to be vaccinated can go somewhere else. Now, I'm not going to surprise you when I say that when you listen to that last line, prepare for it to be reiterated in the employment context using significant different words. All right, so Clausen becomes the most cited case on the constitutionality of mandatory vaccination rules after Jacobson. And it very quickly becomes that way. And I think part of that is the reputation of Judge Easterbrook. And his was a thoroughly elegant opinion, albeit only 7 pages. What comes after Clausen? After Clausen, the courts then struggle for a little while as to what is the legal test we are going to use. Are we going to use strict scrutiny? Or are we going to use the rational basis test? Or are we going to use intermediate scrutiny, that test that the Supreme Court has used for gender discrimination, mostly for gender discrimination? And everybody on this call knows the rules that unless a right is fundamental or an individual is in a protected class, constitutionally protected class, or in some cases statutorily protected class, constitutional claims will be judged on a rational basis test. And the rational basis test means we're not going to second guess the legislature as to whether or not it made the right choice. If the choice it made has any rational basis, we're going to uphold the legislature's decision. And there's a quote, I don't need to read it. This is a case from the city of Chicago. This is Narrow's case. The reference, by the way, to the table is the reference to that table that I described a few minutes ago, containing summaries of vaccination cases. And you can see in this quote that the court says it's pretty easy in the middle of a pandemic. And at the time of this court's decision, the newly discovered Omicron variant, it's pretty easy to say that a governmental body has a rational basis to require its employees to be vaccinated. And you see a bunch of different reasons that are cited by courts over the last few months, everything from we don't want employees to infect other employees to we don't want employees infecting the public to we don't want the public infecting employees. You see a lot of different reasons, but courts are uniform in saying, yes, there is a rational basis for a mandatory vaccination rule. Now, the other arguments that you see in court, by the way, what my plan is to go through the court decisions and talk about them, and then take a deep breath for your questions. And Mickey is going to be curating your questions. And hopefully we can take questions about what goes on in court. And then I will move on to the collective bargaining and arbitration spheres, if you will. So what are the other arguments to say? One that employees cite all the time now goes under the rubric of natural immunity. And I'm sure you've all heard this argument that people who have been infected with COVID have a natural immunity that is at least as great, if not greater, than the immunity that one gets through vaccination. And there've been a lot of different studies on this. The first study that suggested that natural immunity might provide some benefits greater than people who were vaccinated, was a very small, non-peer-reviewed study out of Israel. But since then, there have been a lot larger and peer-reviewed studies that have been performed over time. And we've seen this issue now litigated quite a bit in court. And first of all, let me summarize the science on this for you. Understand you're about to listen to someone who became a lawyer because he could not make it through organic chem talk about science. So take what I'm about to say with a thorough grain of salt. But as nearly as I can tell, this is where the science is right now. And this is not a scaled graph. This shows nothing but trends, and this is nothing but playing around with bars on PowerPoint. So the lowest level of antibodies against COVID, I think everybody agrees, is people who are not vaccinated and have never been infected with COVID. The next level of protection from COVID is those who are vaccinated. but have never suffered a prior infection. Very, very close are those who have suffered a prior infection, but have not been vaccinated. That's the purple column here. And then the ones who have super immunity are those who have been vaccinated and have suffered a prior infection. They're significantly larger than those who have either been vaccinated or infected, but not both. I will say that as we have gone through Omicron, that the second and third bars appear to be reversed, that people who are infected have lower immunity than those who are vaccinated, although it remains close. So that seems to be where the science is. That certainly is where the courts say the science is. And so how does this argument come out in court? This court says, look, you know what? It's not irrational. We're judging these on the rational basis test again. It is not irrational for an employer to want the highest amount of immunity from COVID for its employees, for all those reasons I mentioned before: the risk of transmission of COVID, and the highest amount is the combination of both forms of protection, protection from vaccination and natural immunity. So these natural immunity arguments have failed in court. Next argument we see is equal protection. There's actually a couple of arguments here. And, you know, with an equal protection argument, you're always looking for differential treatment of two classes. And so who's in these classes matters. It matters because it determines the level of scrutiny that the court is going to give to the case. Are we going to be at rational basis test, or we're going to look for a compelling state interest? And it's just relevant in terms of how the court ends up analyzing the case. Well, there have been two arguments, two equal protection arguments that center on this class issue. And one is that the two classes are those who have been vaccinated and those who have not, and treating them differently with respect to their employment. And courts have an easy time of that because there's no reason to apply anything other than the rational basis test as to whether you've been vaccinated or not vaccinated. There have been a couple of cases that say, okay, the two classes aren't those who have been vaccinated and those who have not. There are classes based on race here, because African American and Hispanic individuals, not individuals, communities, are more inclined to get COVID than people from other racial or ethnic backgrounds. And what do courts do with that? Courts say, well, I'll tell you what, that disparity disappears once you look at whether or not they are vaccinated. That disparity between Caucasians, for example, and African American populations, and people in the disaffected populations, Hispanics and African Americans, they can solve the problem simply by getting vaccinated. Don't see that argument come up very often. I'd say you could count it on the fingers of one hand. Next argument. This is one that's still being made. It's kind of surprising, although the argument has morphed a little bit. And this is an argument based upon a series of federal statutes that are in the statutes that create and define the role of the Food and Drug Administration. The FDA has the ability under these statutes to issue what are known as emergency use authorizations. So these are called EUA statutes. And initially, all of the vaccines, all three of the vaccines, the main ones, were authorized by the FDA under the EUA statutes for emergency use. These statutes apply to any medical product. In September of last year, Pfizer moved to permanent authorization Last I checked, and I may be wrong on this because frankly, it's kind of fallen off my radar. I think that Moderna and Johnson have not yet made it to permanent status. They may have, but as you'll see, it's going to be kind of irrelevant. So what is this argument? This argument is that one of those statutes requires the FDA to ensure that recipients of medical products authorized under the EUA statutes make sure that those recipients understand, and I'm quoting, the potential benefits and use, and here comes the important language, the option to accept or refuse administration of a product authorized for use in an emergency. And the argument is that that last phrase means that you cannot have a compulsory vaccination program because individuals, including employees, have the option to accept or refuse administration of a product. And this is an argument seized upon by any number of employees. This picture you're seeing here is a group of individuals wearing t-shirts protesting protesting the mandatory vaccination program of Houston Methodist Hospital. They were the first ones to file a major lawsuit over this. 117 of them sued, challenging the hospital's mandatory vaccination program under the EUA statute, and the court rejected the challenge. The court said that that statute simply refers to the FDA's obligations and doesn't confer a private opportunity to sue the government or an employer or a fellow worker, and that the EUA argument simply is not sound as a matter of law. And the headline that I've cut out from a local Houston paper here, you can see the results. More than 150 employees were fired or resigned rather than be vaccinated from COVID. By the way, sometimes I get asked what employee groups seem to be the most resistant to mandatory vaccination programs. And if you look at headlines, and we try to, at LRIS, the seminar business that Mickey was talking about, we try to collect these headlines from around the country using search engine trawlers. It appears to me that the group of employees most resistant to vaccinations would be corrections officers. And then in this rough rank order, secondly would be firefighters, third would be hospital employees, and fourth would be police officers, and fifth would be teachers. Now that varies tremendously around the country. So for example, in New York City, disproportionately firefighters were the objectors to the mandatory vaccination program there. And yet in Chicago, it was police leading the charge on challenging the vaccination program. Next argument that you see raised sometimes is free speech. This was raised in a case in Oregon filed by not my law firm. We're not filing any of these cases because bluntly, we don't think employees have a reasonable chance of success, and we don't want to get hopes up where those hopes are false. But this one was filed, and one of the arguments was that a mandatory vaccination program violated the free speech guarantees of the Oregon Constitution, which are a little bit more robust than the free speech guarantees in the First Amendment to the US Constitution. And the judge who heard this case, he was a retired Supreme Court justice in Oregon who ended up hearing this on a pro tem basis as a trial court judge. The judge basically said, come on, getting vaccinated is not speech. It's not expressive conduct. Freedom of speech doesn't apply at all in this case. There are a couple of cases that have brought up the contracts clause, both the federal constitution and state constitutions. This is that rather obscure provision in the Constitution that prohibits the governmental interference with contracts. And as the argument goes, mandatory vaccination programs amounts to an interference with collective bargaining agreements, which are contracts protected by the contracts clause. And courts have rejected that argument as well, basically saying, you got someplace else you can go with that argument. You know, if you got a breach of contract, it's called the grievance procedure in your collective bargaining agreement. And this court in Massachusetts, in a Massachusetts corrections case, says there's lots of other reasons to reject a contracts clause argument, but mostly there are emergency exceptions, limited ones, to the contracts, the protections of the contracts clause, and they would certainly apply in a pandemic. International law is another argument you see raised from time to time. It's the combination of the Nuremberg Code and the Helsinki Accords. And kind of shame on me, I had no idea what the Nuremberg Code was or the Helsinki Accords. Kind of guessed the Nuremberg Code came out of the Nuremberg trials that followed World War II. Well, and what they turn out to be are international treaties, more or less adopted by the United States. They have a little bit different histories that prohibit involuntary medical experimentation. And so one of the favorite arguments of plaintiffs' lawyers in these cases is that there were inadequate trials of the COVID vaccines, and thus we are engaged in the greatest involuntary medical experimentation requirement really of all time, because we have now over 1 billion people who have gotten vaccinated or forced to be vaccinated. And the courts reject these arguments. Again, they have uniformly rejected the arguments. First of all, they're completely unconvinced that the Nuremberg Code and the Helsinki Accords impose legal obligations that federal courts in this country are obliged to follow. And secondly, they are also completely unconvinced that a mandatory vaccination program is the equivalent of medical experimentation under either of these codes. And some of the courts pointing to the fact that the trials on the vaccines before they were given their emergency use authorization were the most rigorous trials of any medical product ever in this country. And so this is an argument that just simply hasn't gone anywhere. Best decision on this actually does come out of Oregon, comes out of a federal trial court judge in Oregon. It's this case, Johnson versus Brown, if you're interested. And of course, you can see from the first line of this quote, this long quote on this page, you can see the theme that I mentioned earlier getting picked up by the judge saying, look, a vaccine mandate in employment, that doesn't mean you have to get vaccinated. You have free choice. You can go get vaccinated or not. And your choice is, if you don't want to get vaccinated, you can, in the words of this court in the middle of the paragraph, find employment elsewhere, including potentially in another state. Okay. And then religious discrimination. This is not so much an issue in the public sector because virtually every employer in the public sector that has a vaccine mandate has a religious exemption. This is more of a hypothetical question. Do you have to have a religious exemption? And the general rule here is no, you don't. I mean, going back to Jacobson, right? In Jacobson, there was no religious exemption. But there is a little bit of a pushback on this issue. And the pushback has only come in the last month or two. And it comes in several of the federal cases, federal employment cases involving federal employees. And you can see that represented in this Navy SEALs case that I believe comes out of Texas, if I recall correctly. And the court here, so this is a case that's not over yet. This is simply a decision on interim injunctive relief. The court here says, look, there may be a problem if you don't grant religious exemptions, but grant other exceptions. And that is the constitutional problem of under inclusiveness. And you may end up with a problem here. Jury's out on this. This is a minority opinion. The majority would say no problem not having a religious exemption. But these cases now are popping up a little bit more. So this is one to watch for, this argument of under inclusiveness. So let's talk about the exemptions. And as I said, employers typically have both religious and medical exemptions. The medical exemption is born out of the Americans with Disabilities Act that requires employers to reasonably accommodate an individual's disability. And the religious exemption comes out of really both the First Amendment and Title VII of the Civil Rights Act, including that odd little prong of federal discrimination law known as the Religious Freedom Restoration Act. And all of those give rise to the argument that the employer is reasonably or required to reasonably accommodate religious beliefs. So let's assume that these exemptions exist, and let's assume the employer has to reasonably accommodate somebody's disability. What does that mean? How are the courts dealing with these reasonable accommodation issues? And we have a case out of Texas, out of the Fifth Circuit from 2020, that I think does a pretty good job of stating what the law is. This is a firefighter case, and this firefighter objected, this was not to the COVID vaccination, but to the Tdap vaccination, tetanus, diphtheria, and pertussis on religious grounds. The employer accepted the fact that the employee was entitled to reasonable accommodation, and they went through, the employer and the employee went through the interactive process that's mandated by the ADA and the EEOC's rule. And the city ends up offering a choice to the employee of accommodations. I said, look, Mr. Firefighter, Mr. Horvath, you can do one of two things. First of all, you can transfer to a non-line position, meaning you're no longer in suppression, working in suppression, fire suppression. Instead, you can be in, I think it was inspections that he was in or something like that. You will lose your 24-hour on, 48 off shift. And we understand that you rely on outside employment. And we understand that because of the work schedule for the non-line assignment that we're going to put you on, you won't be able to work that off-duty job. But you can be in this job and not be vaccinated. Your other choice is you can stay on the line with that schedule that you want, and you just have to wear a ventilator 24/7. Horvath said, neither of those accommodations are reasonable. And I've got my own accommodation that I propose. The employer responded, you don't get to pick the accommodations. We do, and these are the only two. Which one do you want? Firefighter said neither. Firefighter was fired and he sued under Title VII. And that's the case that made it up to the Fifth Circuit. And the Fifth Circuit said, employer gets to choose the accommodation as long as the accommodation is reasonable. That's very long-standing ADA law. By the way, it's been the law under the ADA for decades. And the court says, look, Horvath may prefer the normal hours of the suppression firefighter, and he may well prefer not losing the money from his off-duty job, but that does not mean that the accommodations offered by the employer were not reasonable. And that's even before the court gets to, and in fact, it never did in Horvath's case, but a lot of these vaccination cases, COVID vaccination cases do, get to the undue hardship exemption or the danger exception to reasonable accommodation. Under the ADA, an employer does not need to accommodate an individual if to do so would pose it an undue hardship or pose a risk to the public or other employees. And here you see the EEOC weighing in on what an undue hardship might be, and says that the factors you look at are, what is it the employee does, the cost of the accommodation, the number of employees who would receive an accommodation. That becomes important in some of these vaccination cases. For example, in the LA City Fire Department, where that captain was from, initially over 2,000 firefighters requested a religious accommodation. So the number of employees requesting an accommodation does matter. And here you see a court that looks at these issues. I think this was the Fifth Circuit again. And analyzing this, a private sector case, the different reasons that are a reason for a court to conclude that there is an undue hardship. And you can see everything from the administrative burden of having weekly testing, minimum staffing requirements, prior hospitalizations and deaths of other employees, lots of reasons. So a lot of employees think, if I get the religious exemption, and that's, the religious exemption is where probably 99% of the action is on these exemptions. If I get a religious exemption, I'm home free. And actually, that's not the case. Reasonable accommodation does not necessarily mean the employee has the job. Okay. And this I'm going to go through fairly quickly. The EEOC stepped in about 3 weeks ago with very, very good Q&A webpage. This one has been up since we've had COVID-19 on the scene 2 years ago, 2.5 years ago. It's a web page called What You Should Know About COVID-19. And there is a section on it on vaccination and a section on it on what an employer can ask when employees request the religious exemption. And you'll see if you go to it that employers are supposed to kind of default to accepting the bona fide nature of the employee's claimed religious beliefs, but they do have the right to ask questions about whether the employee has acted inconsistently with the religious beliefs now being stated. In other words, an employer can ask the employee, okay, your religious beliefs prohibit vaccination. Did they prohibit you getting vaccinated when you took this job? Or did they prohibit you getting vaccinated when after you took the job? There was a state requirement that you get the Tdap vaccine. And if they didn't, what's different now from them? That sort of questioning, you can imagine. The last thing I'm going to talk about with respect to courts is whether or not courts are intervening in vaccine mandates by issuing temporary restraining orders and preliminary injunctions. And the answer is overwhelmingly no, they are not doing so. Although there is a minority point of view on this. But the significant majority of courts looking at this issue, over 90% by my count, say there's no irreparable harm that justifies the issuance of a TRO or an injunction. And of course, irreparable harm is a showing that is mandatory to get any form of equitable relief. And what's the message that courts give? They cite decades and decades of EEO law and general employment law that for there to be irreparable harm, there must be no adequate remedy at law. If there is, if you can, for example, go through a grievance procedure and get reinstated with back pay, or file a lawsuit and get reinstated with back pay, that's an adequate remedy at law. So there is no irreparable harm. And courts, they're very sympathetic to employees. They say, hey, not easy losing your job. We understand that. But that doesn't mean we're going to issue a TRO. Now, as I mentioned, there is a minority view. This is a case out of Boston, which is one of the places that is now ground central for the debate about mandatory vaccination programs. And here, a court is saying, look, actually what happens with a vaccine mandate is employees are implicitly coerced by the threat of the loss of their jobs to get vaccinated, and you can't undo that vaccination. Therefore, we're going to issue a TRO pending in the Boston case, the completion of the negotiations process. But as I said, that is a minority view. So let me pause right now. And if anybody has any questions over the court opinions on this, let's see if we can take those questions now, and then I'll move on to what arbitrators are doing. So Mickey, over to you.
Will, the one question that we have is, and this is from Pilar Vale, what if any impact on rational basis analysis is presented by the sudden withdrawal of various mask and vax requirements in recent weeks and months as the virus appears to be getting milder?
Pilar, wonderful question. I have not seen the court decision that addresses that issue. There are some public sector employees that at the same time they are ending their mask mandates, are moving to a vaccinate or test model, but there are others that are hewing to mandatory vaccination rules. So for example, the cities of New York, Chicago, and Los Angeles all are keeping their mandatory vaccination for employees rules in place. And since employees in all three places are very, very active in litigation, watch out for one of those three cities to produce our cases on this. And I think it's a good argument. I don't know if it survives the rational basis test. I really don't, because I mean, we've seen over the course of our careers that if you lose the battle or win the battle on which test is going to be applied, whether it's strict scrutiny or rational basis or intermediate scrutiny, you have won or lost your case at that point. I don't know if it's enough to surmount that, but it's the best argument yet on the rational basis test.
Will, one other question on the Jacobson case, and you asked this before or mentioned this before, but is there any chance that the Supreme Court might reconsider that decision?
Let me rephrase that question the way I do in some of my seminars. And the way I rephrase it, and I do not mean to be offensive in the way I put this, do you mean, is there any chance that a Supreme Court that has a 6-3 majority, that is the most conservative of any court in the last century, is going to create a new constitutional right, particularly in the context of employment? I probably have just answered the question. I don't think there's a chance that is going to happen. The court has had the opportunity to take some of these cases up. So for example, Klassen, the plaintiffs in the Klassen, the Indiana University case, applied for interim relief, a stay. And as you know, the Supreme Court assigns those on a circuit by circuit basis to various justices. And that case was assigned to Justice Barrett, who may be the most conservative member of the Supreme Court right now. It's hard to say because they're kind of vying for that distinction. And she refused to get involved. The main case that I had cited, the Jane Doe's cases, where there was no religious exemption, that one went up to the Supreme Court on an emergency stay. And Justice, I think that one was Justice Breyer, turned that one down as well. And there have been a few other cases. I don't think there is any reasonable chance the Supreme Court is going to overturn Jacobson. It would mean you'd be opening the floodgates on substantive due process claims. And I don't think this court wants to do that.
Thank you. Will, it's about 12:58, so we've got maybe 10 minutes or so.
Okay, so I'll talk even faster, okay, Mickey? Okay, so arbitrators, what are you all doing? And I think the big case here, I think the most important case comes from the Chicago Police Department. It was decided about a month ago. by George Rumel. And I think it's important because this was a huge battle in Chicago over whether police officers should be vaccinated. This arbitrator had decided an earlier case, about 2 months earlier, involving the identical issue with firefighters and general city employees. So I think it's important because of the scope of the case and also because of who decided it. George Rumel has for years been one of the most respected arbitrators in the country. And my reading of this, of what happened in this case, is that what was a grievance arbitration, and these were grievances filed by the 4 police unions in Chicago. What was a grievance arbitration got turned by arbitrator Rumel into an interest arbitration as to whether or not there should be a mandatory vaccination program. Now, he phrased it in terms of whether or not the mandatory vaccination program was within the 4 corners of the management rights clause of the contract. But really, when you look at his decision, it sure looks an awful lot like an interest arbitration decision. But whatever it is, he ended up upholding the vaccine mandate. And he cites, as you can see on the bottom of this page, he cites the number of Chicago police officers who've gone on to the medical roll using sick leave for COVID-related reasons, over 6,000. 6 officers have died. And he reviews a ton of medical evidence and ends up saying that the medical evidence supports the city's and department's vaccine mandate as a reasonable exercise of management rights. And that was the ruling he reached in the firefighter and general employee cases. By the way, I don't think this is a published decision, and probably a dozen or so of the cases on the table are not published decisions. If you'd like to see those decisions, just email me. You can find my email at lris.com, and I'll be happy to send you the decisions. What about interest arbitrations? We only have a handful of interest arbitrations. I think the most important of them is out of Philadelphia. Arbitrator, I've never known how to pronounce Alan's name, Simonette or Simonette. And this case is about 3 months old now, and it involved general employees. He ended up ruling in favor of a vaccine mandate, and he eased the sting a little bit for the union by giving employees a $300 bonus and a ruling that side effects from the vaccine would be considered to be work-related injuries for purposes of the workers' compensation system. Every arbitrator that I have seen looking at a vaccine mandate thus far has upheld the vaccine mandate. As I mentioned earlier, this is an overriding message that you see from everybody looking at these cases. Look at the last lines, 2 lines of these quotes, of this quote. Ms. McCutcheon is free to accept or refuse the COVID-19 vaccine. If she refuses, she need only to pursue employment elsewhere. I'm going to skip this slide. It just shows how people of my breed, if you will, lawyers, are behaving horrifically in this whole area of the vaccine mandate. What they are doing are making promises to employees, soliciting money from employees in Los Angeles in one of those police and fire cases at the rate of $2,000 per plaintiff to file lawsuits that have virtually no chance of success. So it's very, very frustrating. Okay, I want to finish about the rules with respect to whether vaccine mandates are negotiable. Not a lot of decisions on this issue, okay? There's one that didn't make it on your table that's from a hearings officer for New Mexico's Public Employment Relations Board that was decided, I think, on Friday, very, very recently. And most of the cases, like I said, there's not a lot of them. Most of them say the decision to impose a vaccine mandate is not negotiable, but the effects of that decision are negotiable. Nobody knows exactly what that means. How do you distinguish between the decision and effects in the context of a vaccine mandate? For example, is the notion that non-compliance means you're going to be discharged in effect, or is that a decision? Nobody quite knows that. But that seems to be the rule. And the main case here is a California Public Employment Relations Board case from the middle part of 2021, drawing this distinction between decisional and effects bargaining. The importance here is that if you have negotiable effects, typically negotiable effects have to be negotiated before implementation of the decision. Although in many states, there are emergency exceptions to that allow the decision to be implemented so long as the employer continues to go ahead and bargain the effects. Now, there is a minority rule. I'm going to skip this next slide. I'm sorry about that. There is, or the next two slides, there is a minority rule. This comes to us from the New Jersey Supreme Court, and the New Jersey Supreme Court in a horrifically reasoned case. And again, I say that without regard to result, decided that there's nothing negotiable about a mandatory vaccination program, either the decision or the effects. It's easy to predict that the New Jersey Court of Appeals is going to have to clean that decision up in a series of cases not involving vaccinations for many, many years, because it did a lot of damage to the notion that there can be such a thing as effects bargaining. Finally, what do employees want to bargain about? What are we talking about at the bargaining table? Testing is an alternative. So for example, in Austin, they were successful. The parties, City of Austin, firefighters, police, were successful in bargaining for frequent testing as an alternative. The bottom bullet, I've been at the table and have proposed quantitative antibody testing as an alternative to vaccination. So if an employee could prove that the level of antibodies was at least equivalent to that they got from the vaccine, they would not have to get vaccinated. People want to bargain about the use of non-disciplinary layoffs or leaves of absence as an alternative to discharge, particularly when we've seen the pandemic periods when the pandemics have been eased. Reassignment to non-public facing positions, that's easy, but it's not very easy to do in the public sector, except when you're already under lockdown. The last bullet on this page, kind of important. What do you do with employees who are within their final average salary period for retirement purposes? Do you want to have special rules for them so that their pension isn't affected for the rest of their lives? And some employers have gone to that sort of differential treatment, particularly the state of Washington, which had a mandate for all state employees, put those sorts of employees on a leave of absence. Unions want to talk about the scope of the religious and medical exemptions and the information that has to be provided and the appeal system from discipline. And of course, they want to talk about incentives, right? Either extra time off, or some places we've seen that Philadelphia decision involving money, and things like Weingarten type representation for meetings involving non-compliant employees, and perhaps a special dispute resolution process where a single panel of arbitrators or a single arbitrator hears all of the cases. So you don't have to repeatedly educate arbitrators on the medical information that they need to know to make these decisions. So that's it. It's a bit of a very brief run through of vaccination law. If there are any questions, I'm happy to answer them. And if you go back to your homes and you have a question tomorrow or the next day, email me. I'm happy to try to get an answer to you.
Well, we had one question. Do you know if the arbitrations that you cited were held in person with reasonable safety precautions, or were they done virtually?
Good question. I don't remember seeing a reference in any of the arbitration decisions as to whether that happened, whether they were remote or not. By the way, Mickey, just quickly, if I can get on my soapbox for 10 seconds, I hate remote arbitrations. Okay, I'm off my soapbox.
Some of us would feel that same way. One other question, any FLRA activity in this area?
Not that I have seen that has resulted in a published opinion. There are some old, by the way, NLRB cases involving vaccination that do find that mandatory vaccination programs are mandatory subject to bargaining. I think the leading one is out of a Seattle area health facility, but I don't remember anything from the FLRA.
Will, could you give your email address in case people want to send you some questions?
Sure, it's WILL@LRIS.com.
Thank you very much. Just a couple of closing comments here. Will, this is a fantastic presentation. You really did a great job of covering a whole lot of information. So thank you so much for doing that for us. And I think everyone certainly benefited from it. I certainly want to thank Emily and Bernadette for doing all the technology work and helping us with communications. I'd ask you to mark your calendars for May 26th. We have another presentation coming. This one's going to be in partnership with the Southwest Rockies NAA group. And it's actually one of the presentations that was going to be in the February Southwest Rockies conference that was canceled in February. So we're going to do two of those with them, and this would be the first one of those. Let's see. And the second of those will be in September. And Emily, do you want to say anything about the National LERA meeting?
Sure, you're all invited to attend our national 74th annual LERA meeting. It will be virtual this year, so it will be easy to attend, and it's about half price of what it typically costs. We'll have, I don't think I've actually counted the number of events, but it's somewhere around 90 to 100 different sessions, like the one you saw today. And they happen over 4 days. There are 6 to 8 different events at any given time, all day long for that 4-day period, June 2nd through 5th. And we would love it if you would attend. Registration is open. It's at our website. Our website is leraweb.org, and we'd love it if you'd come. Thank you so much.
And finally, I just want to thank everyone who took the time out of their busy schedules to participate in this with us. We appreciate that. I hope you might be interested in joining Houston LERA. And thanks to Moretta for getting the MCLEs done. That is always a good thing to have. So with that, we'll close it out, and thank you again. Take care. Bye, everyone. Thanks, Will.